Hello again, it's Dustin Pascal and Paul Simon with Simon Pascal Says, your tips and information on employment and business related topics. Today we're going to talk about something that I think employers have a lot of questions about and come to us a lot about, which is the concept of reasonable accommodations under the Americans with Disabilities Act. So why don't we kind of start with just generally, is there a way to tell an employer, here is a reasonable accommodation to provide?
I mean, no. There's really not a definition of this is a reasonable accommodation. It's going to be very fact-specific. It's going to depend on the nature of your business, the nature of what the employee is needing. And so that's why, when you hear reasonable accommodation, what a lawyer is really going to talk to you about is engaging in the interactive process. And that's essentially kind of determining what the employee needs. And oftentimes the best way to figure out what the employee needs is to have them provide a doctor's letter. And the doctor should have the employee's job description so that the doctor kind of understands, what the essential functions of the job are, and then that the doctor understands the health issues that the employee has and provides what the doctor believes may be a reasonable accommodation. Now, if the doctor provides a reasonable accommodation, would you say that that has to be the reasonable accommodation the employer needs to provide?
Yeah, I think the key there is the reason that's the preferred method is to take it out of the hands of the party that has kind of some bias in the process, which is the employee, because the employee's asking for an accommodation. They want something, so that employee is going to choose the thing that they want the most, not necessarily the least cost to the employer or the least burden to the employer that still accomplishes the thing. So you want to take it out of the hands of that biased party and put it in the hands of the doctor. Now, to answer your question, though, when it comes to, hey, whatever the doctor says, is that what I've got to provide? And the answer to that is no. Probably. Meaning, referring back to the beginning, is we can't give you a per se answer, here's a reasonable accommodation, here's a not. But there's nothing in the law that says what a doctor says is per se a reasonable accommodation. Because what reasonable accommodation means is, what does the employee need from a medical standpoint to perform the essential functions of their job, taking into account the burden on the employer, cost, efficiency, other employees, whatever it may be. And so the doctor is not taking those things into account when the doctor makes their recommendation on here's what the reasonable accommodation is. So the employer takes that, then goes and looks at their workplace, the job, the essential functions, costs, all those kinds of factors, and takes into account, is this a reasonable accommodation that I am required to provide?
Yeah, and that's, when I talked about interactive process, what you really should be seeing is somewhat kind of a ping pong. You go to the employee saying, please provide a reasonable accommodation from your doctor. Doctor provides it. If it's something that you don't believe you can do, whether because you don't think it's reasonable, whether it's undue hardship, or perhaps because based on what the doctor said, you think there's an alternative. Paying it back to the doctor, the employee say, would this work? And oftentimes the doctor, again, is just taking what the employee has shared with them regarding what the employee would prefer, what the nature of the job is. And so you giving the doctor something else to consider, the doctor may say, yeah, that would actually work for this situation. That's a reasonable accommodation. So you really want to see kind of the back and forth. I think where we see companies get hung up is the more of a brick wall. No, that doesn't work, try again. No, that's not a reasonable accommodation, with no sort of attempts to kind of say, but this is something we could provide.
Yeah, and I think two things to kind of wrap it up is, one, you talk about interactive discussion a lot. It's a violation of the law for an employer to fail to engage in the interactive discussion. So that in and of itself becomes a violation for the employer. And then the final thing I would note is you hear us saying reasonable accommodation, reasonable accommodation, reasonable accommodation. the question we always get is, well, what's reasonable? And the answer we have is that's for members of a jury to decide at the end of the day, really, because you don't know what a reasonable accommodation is until a decision maker, either a jury or a judge, says this is reasonable or this is not. And so that's why as lawyers, we can't ever tell you, yes, that is a reasonable accommodation, or no, it's not. It's we believe this is a reasonable accommodation, or we believe it's not. But reasonable is determined at a later date. You're making, really, at the end of the day, as an employer, your best guess as to reasonableness, which is the case for most things under the law. There's a lot to it. There's a lot of things to know. There's a lot of gray area, which is why it's best to kind of really dig into that, take your time, speak to your legal counsel. But there you have it for reasonable accommodations in 5 minutes from Simon Pascal Says. We'll see you next time.